Good afternoon and welcome to today's webinar hosted by Credit Today. I am here today with Keith Costa, Melanie Signagi, and Scott Hazen, all members of the firm at Otterberg, who will be presenting on the involuntary petition. Is it a sword or a shield? Should it be utilized or avoided? A few quick items to get out of the way before we begin. Within the first 10 minutes of this presentation, we will host 2 live polls. Please remain by your monitor to submit your response and receive the live results. If you have any questions during the course of the presentation, you can ask them through the questions function on your side panel. We will gather all those questions and save them for a Q&A at the end of the presentation. If you are looking for a copy of the slides to follow along today, they are available through the handout section in your side panel. We will also be sending a copy through email after the presentation is complete. The last item is that we will have a brief survey that pops up after the webinar ends. It only takes about 30 seconds to fill out, but gives us a lot of great information on how we can continue to make our webinars better for you. Now to give you a little background on our speakers. Keith Costa joined the firm in May 2017 to work primarily in the firm's restructuring and bankruptcy department. Mr. Costa has acted in many fiduciary roles throughout the years, including serving as Chapter 11 trustee, Chapter 11 examiner, counsel to official committees of unsecured creditors, and counsel to board of directors. Listed among the top bankruptcy lawyers in Manhattan by super lawyers. Keith is also a court-certified mediator in the bankruptcy courts of both New York and Delaware, frequently serving in the Madoff and Lehman Brothers cases. Judge Melanie Signagi became a member of the firm in 2008 after serving a full 14-year term as a bankruptcy judge in the Eastern District of New York. Now serves as the chair of the firm's restructuring and bankruptcy department. From November 29, 2005 to the end of her term, she was the chief judge of the court. Judge Signagi practices in insolvency and bankruptcy litigation and is also an active mediator, having mediated cases in bankruptcy and federal cases throughout the country. Scott Hazen is a member of the firm, a recent past member of the board of directors and chairman of the insolvency department of the firm. For more than 40 years, Mr. Hazen has specialized in all aspects of bankruptcy, including the representation of creditors committees in Chapter 11 proceedings, creditors committees involved in out-of-court workouts, forbearance arrangements, and restructuring agreements, acquirers, lessors, and lenders. I would also like to acknowledge Credit Research Foundation for their permission to share the results of a survey conducted for a panel on this topic at the CRF conference held in March in New Orleans. As a platinum sponsor of the Credit Research Foundation, Credit Today is able to bring this expertise to its members in partnership with Otterberg. And with that, Scott, Melanie, and Keith, it's all yours.
Okay, Roxanne, this is Scott, and thank you very much for that introduction. We're going to flip around amongst us colleagues here at Otterberg for various parts of the program. Just as an opening point, this program, which started at CRF and has now continued here at Credit to Be, is based upon a real-life experience by at least one of the senior credit executives out there who really wanted to do an involuntary petition to preserve value for his company, but could not get 2 other petitioning creditors. And that inability cost his company millions of dollars. So this program is designed to make sure that you know what your rights are and hopefully facilitates your ability to get partners in filing an involuntary when it is appropriate to do so. So on tab 4, which we put up on the screen, we are showing the first poll that CRF conducted in advance of the program, which posits the question, have you ever considered participating in the filing of an involuntary petition in bankruptcy? It has no timeline associated with it. It's forever. Did you ever consider? And interestingly enough, because it was a surprise to me, and you can see the statistics, 57% said yes, they had considered it, and 43% said that they hadn't considered it. That was a surprisingly high percentage of folks who had considered it. If you then turn to tab 5, and in a moment we're going to do the 2 polls that Roxanne mentioned, it takes it to the next step, which says, have you been a petitioning creditor? And in the CRF poll, as you can see, very low percentage actually, after thinking about being a petitioning creditor, actually participated as a petitioning creditor. And these percentages did not surprise us at all. With that, Roxanne is going to launch the first poll, which is not time sensitive. It asks a question without consideration of years, whereas the second poll, similarly sounding, talks about the same question, but only since the year 2005 when the law changed. Roxanne?
All right. I have just launched the first poll.
And while people look at the poll, in a minute Roxanne will tell us the results. Hopefully people are just snapping away with answers. We'll see how it compares to the question on tab 4, and then we'll compare it to the answer on tab 5.
All right, there is no more movement on the first poll. 22% responded yes, and 78% responded no.
Okay, so that is participating as a petitioning creditor with no time considerations. The second poll asks the same question, but since 2005 when the law changed. Why don't you launch that one, Roxanne?
Second poll launched. Okay, it seems as though the voting has stopped. 15% said yes, 85% said no.
Okay, so on the first poll, the 22% yes is not too dissimilar to the 29.8% that CRF had found. And that does not surprise us. The second poll, which shows a lesser percentage, that as a lesser percentage surprises us, and when you're done with the program, maybe it will surprise you. But the fact is that law has only been in place 10 or 12 years. And as we learned, not every credit executive is really familiar with what the involuntary petition may do to their company. I submit in 5 years from now, when that second poll is conducted again, there will be a materially higher percentage that actually participated in an involuntary petition. Let's go to tab 6. At CRF, they asked, for those who did participate in involuntary bankruptcy, how would you report the outcome? 33% had a positive, 23% and change had a negative, and 43% didn't care. It was neutral. We had no particular reaction to that, though in a minute we're going to go through, and Melanie's going to do that, some of the consequences which may very well have influenced the positive and negative and neutral responses. Melanie, tab 7.
Thank you very much, Scott. So looking at tab 7, we're looking at the issue of for those who did participate in an involuntary proceeding, were there any unexpected consequences to their participation? And as Scott indicated, the survey was done in anticipation of the CRF conference held in March. So the survey happened sometime in early 2017. Of those who answered this question, moving to tab 8, we have a couple interesting responses in narrative form. The first was that you must be absolutely sure of your facts. In the case that I was involved, the customer filed a Chapter 7 bankruptcy before the involuntary was actually filed. So it's interesting that from a timing perspective, and clearly you want to look at this, but you may or may not know because involuntaries could be filed in a different jurisdiction than the voluntary petition by the underlying debtor. A second response given was, quote, the attorney dropped the ball, unquote.
By the way, we confirmed with CRF it wasn't anybody we knew.
And that was about all we were able to confirm. We have no idea what it was that the attorney did or didn't do. A third response deals with the issue of preferences, and it was simply preference claims. Presumably, the creditor, the petitioning creditor who filed the involuntary, filed it at a time when it was within the preference period.
And by the way, Melanie, let me interrupt. When we or other good law firms assist creditors in preparing for the filing of an involuntary, one of several questions that we ask is, have you received any payments within 90 days of this date? Because if you have, the filing of the involuntary will trap those payments within the 90-day preference period, and then you may find your involuntary petition was like shooting yourself in the head to shoot the debtor in its foot. And so that's an important consideration.
And it's especially important, as you pointed out, to not only be sensitive to the timing for preferences, but as we'll be talking about in a few minutes about the 503b9. So the fourth response given was, in terms of unexpected consequences, quote, not really, although it did seem that it took a long time to close out, unquote. We don't know if they're referring to the closing out of the involuntary from the time it was filed to making it a regular case, or just the fact that the bankruptcy case went longer. Turning to the ninth tab, another response was, quote, no consequences other than we were aware we may be countersued, but that may not happen. This is certainly something that we'll speak about a little bit more fully. What they mean is that if there are inadequate grounds for the filing of the involuntary, then the petitioning creditor may indeed find itself facing allegations of that kind. The next response was, no, they didn't learn of or realize any consequences, quote, other than the paranoia of my management about potential consequences. Another response was no consequence other than I expected a resolution much sooner. The next one was it was hard to find a third creditor, and that we can absolutely appreciate. And lastly, I forced the company into bankruptcy because the principal was incapacitated.
With that, we're going to turn over to Keith on tab 10.
Hi, Keith Costa here. So the next one is, for those who participated in an involuntary bankruptcy, do you feel the outcome achieved was better or worse than if the case were voluntary filing? And as you can see, the response percentages were better, 75% in the affirmative, worse, 25% in the affirmative, in the negative.
And actually on that, though, I personally didn't have any expectations. I was very pleased that the overwhelming majority had a view that it had a better outcome. I've heard too many horror stories where the opposite turned out to be the case. So that was welcomed.
Right. And in general, I mean, I always ask, does it ever make sense to file an involuntary? And, you know, once we get through all the points that we're going to raise in this webinar, if you can answer in the affirmative, then it is a good way to stop the debtor dead in his tracks.
Okay. Keith, tab 11.
Right. The next one is on, for those who did not participate, what factors drove you to decline participation? And then you'll see the various answers, and the percentage will start with the highest percentage. 50% did not want to participate due to the factor of time commitment. Obviously, anytime you go into court, there's a certain amount of time involved, and that's the largest percentage there. The next, of course, 44.2% expense commitment, which I suppose goes hand in hand with time spent in court. The third largest, 32.7% response, is referring to the travel commitment. We'll talk more about that later. 17.3% company policy on bankruptcy involvement. We know that in a lot of companies, they don't want to file an involuntary, they don't want to serve on creditor committees, there's just company policy that must be followed. Then the lowest amount, 11.5%, reason to not participate, the company position on media exposure.
And each one of those, from our collective experience, are appropriate responses, and it's something that we specifically address whenever the subject of an involuntary petition comes up. And though in normal course it isn't a big time commitment, in the normal course it isn't a big expense or travel commitment, can't comment on company policies because we will talk about that in connection with the real life experience that provoked this panel. So all these concerns are well founded, but in the normal circumstance, they're not really that relevant.
And one thing to point out before we get into the next section on 503b9 is the difference between participating in an involuntary and a voluntary. The involuntary period may be as little as 21 days or 30 days by the time you have the filing of the petition to the time that the court is required to rule on the involuntary petition. It may be a longer period if the parties engage in discovery and other issues like that, but in the ordinary course, the time that's dedicated solely to the involuntary need not be that great or that long.
Okay. So why is it a topic for today's audience? And Melanie touched upon 503b9, 20-day goods claims, and we touched upon when you're being asked to file an involuntary or when you're considering it, you have to think about your 90-day preference exposure. But the incentive and the inducement that Congress created in 2005 for the filing of an involuntary, or this panel, relates to 20-day goods. And it arose out of a credit executive, as I said earlier, who had millions of dollars, and he knew that his customer was going to file a bankruptcy. I think it was even conceded by the officers of that customer, and it was all over the trade publications and elsewhere. And he had shipped in within 20 days an awful lot of stuff. And he saw, hypothetically, on the 21st day before what might be a bankruptcy, he saw that his 20-day goods claims were about to start evaporating on a per diem basis. You know, it's the invoices on the given day, the shipments on the given day. And he could actually look at a schedule and see how his money was disappearing off the table. Now, before 2005, there was no 20-day good provision. The only provision you had was for reclamation claims, which was a totally different kind of relief, not easily obtainable, and over the decades was almost never obtainable. But when 2005 came about, Congress, with lobbying efforts by major trade organizations, was surprisingly successful in obtaining this provision. So what is this provision of 503b9? It's a provision enacted in 2005. Its goal was to induce vendors to continue to supply goods. Now, the word goods is important. It is not designed to induce or protect services. So it was to induce vendors to continue to provide goods on a normal basis, notwithstanding the financial situation of a customer. And the statute accomplishes that inducement by saying the value of any goods received by the debtor within 20 days before the date of commencement of a case, I'm going to leave out some of the words, in which the goods have been sold to the debtor in the ordinary course of such debtor's business, is automatically granted administrative Chapter 11 claim status, even though the sale occurred within 20 days prior to the bankruptcy. To put that in English, the amounts you're owed for the 20-day deliveries, poof, become Chapter 11 claims. They jump to the head of the food chain. They are ahead of all unsecured claims. By the way, they're ahead of tax claims, wage claims. They jump to the head of the class. And Congress believed that that would be very helpful to vendors and debtors who are struggling to survive because people start cutting off credit, as you all know better than we know, when the customer starts experiencing financial distress. Now, typical of lawyers and legislators, when we write a statute or when we try to interpret and enforce a statute, we figure out how to create problems. And problems exist, though as a general rule, they're not too complicated. But if you look at the words of this statute, the issues on tab 13 include whether or not goods were provided. As I just said, services are not covered, though you can have a manufacturer, a provider of both services and goods, and then the issue becomes what are the services and what are the goods, and how will the court treat the claim that is situated in both camps. Another issue that arises is whether the debtor received the goods, and we're talking about the debtor receiving it versus a non-debtor entity. So if you're drop shipping to a different location versus the debtor, it's not going to be received by the debtor. It's going to be received by somebody other than the debtor, and you won't qualify. And it has to be within 20 days of the petition, and so we have proof issues of when receipt occurred. What is or are the value of the goods? Is it the invoice price, or is it something else? What if the goods were not conforming? What if there were other issues concerning the goods, defects? So an issue can arise on the value of the goods. Were the goods sold to the debtor in the ordinary course of business? Seems to me that should be an easy one, but we can go through facts where it wasn't so ordinary, and a debtor could dispute that. And then finally, if you pass all of those hurdles, there's no clarity in the statute. When will the claim get paid? I think Congress, I'm now speaking for a bunch of legislators who I've never spoken to, and the history behind the statute is weak at best. So when I say I think Congress believed that they were enacting something that would allow vendors to get paid immediately, the vast majority of the cases do not produce that result. And often you have to wait, and often it's not clear as to what you need to do or not do in theory, as opposed to reclamation of goods, where there are things you must do. For 503b9 goods, in theory, you're not required to do anything. But sometimes the debtors don't do anything, and then you may wish to act. Tab 14 is the issue of that this credit executive faced and you face. If you've got a distressed debtor owes you money and you shipped in goods recently and you learned something that said, holy cow, I'm not going to get paid, and the debtor isn't doing anything, because every day that goes by, the clock ticks. Every day that goes by, there's an erosion of your 20-day goods claim, because all of a sudden it becomes a 19-day goods claim, an 18-day goods claim, and at some point, when 20 days after your last shipment has occurred, you have no 20-day goods claim. So as an example, a vendor might be owed $20 million for goods delivered 20 days before the bankruptcy, and assuming that $1 million a day was shipped in, that vendor lost $1 million a day as each day slipped by. And to the extent you file an involuntary on the 20th day, subject to the involuntary ultimately succeeding, and we'll talk about that in a minute, and the debtor declared, I'll use old jargon, bankrupt. It's actually called an order for relief. The involuntary sticks. Until that happens, you're not sure what's going to happen, but you have preserved and frozen your maximum amount if you do it 20 days before. Otherwise, you morph, and your $20 million claim in this example will become a general unsecured claim. And in the case that prompted this program, instead of getting paid 100 cents, which all the 20-day goods that were still around got, the vendors and service providers received materially less than 100%.
I believe it was less than 10% in the actual case. The other thing of interest, Scott, is not only should you as the creditor be counting, you can be pretty confident that the debtor is counting also. They're keenly aware of what their 503b9 claims are. So just as you're you're seeing your 503b9 erode from the debtor's point of view, they're delighted that no one's filing an involuntary against them for the opposite reason.
Okay, tab 15.
So let's move into what is the involuntary petition. And the easiest way to think about an involuntary petition is that it's just like a complaint that you would file in any other litigation. Importantly, you can only file an involuntary petition in a Chapter 7 or a Chapter 11 case. You cannot file it in a Chapter 13, which is what we often refer to as the working person's reorganization, or a Chapter 12, which is the reorganization for farmers and farming businesses. And so as you see in sub B there on slide 15, the petition can be filed against any person that may independently qualify for filing of a voluntary petition under Chapter 7 or 11. It cannot be filed against a farmer, family farmer, or a corporation that is not a moneyed business or commercial corporation.
And it also cannot be filed against a municipality, and the city of Detroit was a Chapter 9, and you cannot file an involuntary against a Chapter 9 eligible entity.
Absolutely. The other specific issue you need to think about when you're filing an involuntary is how many creditors does the potential debtor have? And the reason why you need to look at that is that Section 303 of the Bankruptcy Code of Chapter 11 talks about and requires that if a potential debtor has 12 or more creditors, then the petition must be filed, must be signed by 3 or more entities, each of whom has a claim that is not contingent and is not the subject of a bona fide dispute. And collectively, the claims of these 3 creditors must aggregate at least $15,325, and that sum must be net of the value of any, the net of any lien protecting the claims on the property of the debtor. An example we use is that one creditor can have a $15,325 claim. Each of the other 2 can have a $1 claim. That is sufficient so long as the aggregate exceeds this threshold of $15,325. Now, for your convenience, we've attached at the end of the webinar materials as Exhibit D a complete reading of the provisions of Section 303 so that you can look at it. Now, if the potential debtor has fewer than 12 creditors, excluding employees or insiders or recipients of avoidable transfers, then the filing can be done by a single creditor, so long as this aggregate of $15,325 has been met. Now, assuming for the moment that this petition was filed, the next order of business from a process point of view is that the alleged debtor will have 21 days to answer it You'll find that in Rule 1011. So turning to slide 16, the obvious question is, how do you know if there are 12 or more creditors? The short answer is you're probably well aware of the debtor's situation given your proximity to the business by reason of being a creditor. You'll know whether or not it's a big company, a small company. You'll have a good idea of whether or not the debtor is paying its debts as they become due based on your own experience. It may be that you know competitors of the debtor who, like you, are experiencing the situation where the debtor is not paying its debts. Sometimes you can look in public filings and get a pretty good idea. But the short of it is that if you fail to have 3 and you need 3, Rule 1003B will provide you with some additional time. In other words, the court, if you only have one petitioning creditor and the debtor shows that it has more than 12 creditors, then the court will require the debtor to actually tell the creditors who are its other creditors, and you'll have an opportunity to get at least 2 more. As slide 16 also points out, there are other rules about filings, if you're trying to file an involuntary against a partnership. So look at the statute for guidance in that regard. Now, what happens when you file an involuntary petition? It can either be granted or it can be dismissed. If there, in many instances, frankly, upon the filing, nothing happens. The alleged debtor doesn't respond. In that instance, upon the passing of the time, the court will simply grant the relief and direct that an order for relief enter, and it will then operate as if it were a voluntary bankruptcy. It's possible that the debtor will controvert it. If that happens, then you will have a trial, and it'll be a trial on an expedited schedule, because under the rules, this case gets priority. All of the discovery rules under Part 7 of the Federal Rules for Bankruptcy Procedure will be operative. At the end of the trial, or upon motion, it's possible that the court will not grant the petition and dismiss it. If that happens, then it's dismissed, and the question is what happens upon the dismissal. But let's assume for the moment that we have this period of time from the filing of the involuntary until the time that an order for relief is entered. What happens during that time? The short answer is that the debtor, or the alleged debtor, operates its business just as it would as a debtor in possession. This time period is known as the Ghast Period. If there are any expenses and debts during this gap period, they'll receive priority in the ultimate waterfall of distributions. In the event that it's dismissed, then the case is simply dismissed, although this may be an opportunity for the debtor, for the alleged debtor, to seek recourse. But before we turn to that, looking at slide 17, let's take a moment to think about some of the other potential things that can happen during an involuntary. While it is an extraordinary relief, nonetheless, it is possible for you as a petitioning creditor to seek the appointment of an interim trustee. What this means is that during the period between the filing of the involuntary and the time when the court determines whether or not an order for relief should issue, an interim trustee actually takes over the running of the business, just as a Chapter 7 or Chapter 11 trustee would in the ordinary bankruptcy case. Before you seek to have an interim trustee appointed, though, you should be aware that Rule 2001 of the Federal Rules of Bankruptcy Procedure requires that the movement post a bond, and the bond will be in the amount set by the court. but the idea behind the bond is that a trustee and the trustee's professionals come with a cost, and in the event that the case is dismissed, then those costs should not be borne by the alleged debtor, but rather by the movant. That's the factor that you need to think about when you think about whether or not you want this extraordinary relief. Now, turning further to what are the consequences that can happen, as noted, if it's not opposed, there can just be an order for relief that issues. Otherwise, the court will enter an order for relief if the debtor is found to not be paying its debts as they become due. The court will also direct an order for relief if a custodian or a trustee, a receiver, or an agent has been appointed to take charge of the alleged debtor's property within 120 days of the filing of a bankruptcy petition. But the part we want to point out is that this does have its risk, and the risk is noted in sub K of slide 17, that namely, if the court were to dismiss a petition other than on consent, then it's possible that the court will grant a judgment against the petitioners and in favor of the alleged debtors for costs, including the reasonable attorney's fees that the debtor incurred, or any other damages that are consequential to the filing of the involuntary petition, and there may also be punitive damages awarded. Now, the basis for all of this relief is the concern of Congress that they didn't want this tool to just be used wantonly without folks being aware of the consequence. One of the interesting parts of Rule 303 is found in sub K of that provision, which talks about if an involuntary is filed inappropriately against an individual, the court has the direct authority and power to direct a consumer reporting agency to not report this involuntary petition and to take such other steps as may be necessary to ensure that the filing of the inappropriate involuntary does not forever ruin the credit of that individual.
Keith, on tab 18.
Yes. So now we're looking at the pros and cons of an involuntary petition and issues that you must consider as a creditor. Obviously, the most important one is, as Melanie just talked about, A, the risk of being a petition creditor if the involuntary petition is not successful, beyond the fact that under Section 303I, if the court dismisses the petition, you're going to be on the hook for costs and also reasonable attorney's fees. There's also the provision further down, let me read it to you, under 303I1, 1A and B, and then 2, I talked about the costs and the reasonable attorney's fees. 2, against any petitioner that filed the petition in bad faith. And obviously, that's a real risk. If there is bad faith, you have to, just practically speaking, on that point, and we don't have time to go into the Forever Green Athletic Fields case. It was a recent Third Circuit decision. Petitioning creditors have to concern themselves with determining the subjective motivation of the creditors, not just your own motivation, but your fellow creditors before you join in the filing of an involuntary. Because the worst thing you want to do is to be found guilty of bad faith. And you have to exercise extreme caution, not just for yourself, with proper due diligence, as any good businessman would, but also your fellow creditors. Now, B, the pros and cons, is risk of creating a preference exposure. Scott was talking about that, and we're talking about what I call the 89-day preference, because there are preferences to be set aside and other bankruptcy powers to be deployed, because as we talked at the beginning, once an involuntary files, that counts as commencement of a case. Melanie just talked about an order for relief, but before that ever happens, the day of filing is commencement of the case. So that triggers an automatic stay, which starts the count on the period for avoiding preferences. There are many other possible examples, and we got into the statute of limitations as well. And C, as noted above, every day that goes by creates an erosion of potential 20-day goods claim. Scott talked about that. So the 503B9 claims, you don't want to lose money as it slips off the table because of bad timing. D, large companies are not excited about filing involuntary petitions against customers due to, among other factors, bad publicity. I guess that cuts both ways. Obviously, you have to follow your company policy, but in the right circumstances, if it ever does make sense, like I said at the beginning, it's a great way to stop the debtor dead in his tracks.
Though we saw from the survey, that was one of the reasons people were reluctant to participate.
Right. And the other point in E here, the cost and potential time consumption, travel potential. Again, that was also an issue in terms of cost and time. Travel, I honestly don't see that. I've never experienced that.
The travel expense and the time comes up with, and Melanie touched upon it, discovery, potential trial. And I am confident that in the vast, vast majority of any involuntary anybody on this phone would participate in, you're not going to have any of that. But you can. And on slide 19, we'll talk about a case where they had discovery, and therefore you may have to go to a deposition. You may have to be a witness in court in the state in which you filed the involuntary. So yes, theoretically, there is that kind of potential. Tab 20.
19.
19, I'm sorry.
Okay. So in 19, we're looking at F. Often an involuntary petition is filed to protect not only a 503B9 20-day claim, but as I referred just briefly, the statute of limitation issue, as in the case of Caesars. And as we describe in the tab, in the Caesars case, certain unsecured note holders filed an involuntary petition just prior to the lapse of the 90-day preference period in order to retain a cause of action of the estate in bankruptcy against the secured creditors, who within 90 days of the involuntary petition allegedly acquired a lien on over $400 million of quote-unquote cash through a lien on bank accounts. More recently, there's the Central Grocers case I think Scott wants to have.
Right. Well, what's interesting on tab 19, this panel, this webinar, is designed to address why you file an involuntary or might to preserve your 20-day goods. Caesars is one of the other reasons why you file an involuntary within 90 days to preserve your causes of action. I was very pleased shortly after the panel in CRF in March, on which we had two vendor participants and Melanie and myself, one of those panelists joined in an involuntary petition against a customer. He was successful in finding two others, and together they filed an involuntary in Chicago in a case called Central Grocers. And as opposed to Caesars, where lots of litigation ensued relating to lots of different things, there was a quick resolution in Central Grocers, because 2 days later, the company filed their own voluntary in Delaware, and then the case was transferred back to Illinois. And so there really only was arguably 2 days in question as to whether or not did the case commence on the date of the involuntary, or did the case commence 2 days later when the voluntary was filed. And I'm sure a resolution will or has been reached. But it's a great example where our panel had an immediate result, and the vendor community learned how one can preserve 20-day goods claims. And I've conferred with the petitioning lead creditor, and son of a gun, the reason he filed was to preserve his 20-day goods claim. Tab 20. And Melanie has touched upon this. You can get an answer. The debtor can fight it. Happens periodically. It can contain affirmative defenses and counterclaims and seek to go against the vendors, alleging all sorts of dastardly deeds. or they can consent, or they can consent and convert. They could file a separate petition, but in your normal, if there is such a thing, involuntary, you're going to find the debtor either does nothing, as Melanie said, and the judge enters the order for relief, or the debtor consents to it, or the debtor files its own, and you don't have any rigmarole or issues, but you must consider, as we have in this panel, this presentation, what certain issues may be and may arise. And what you should take away from this webinar, subject to questions that may or may not be posed, is you have another arrow in your quiver. You have something you should seriously think about, which before 2005, your motivations were just not there, and it's a tool you should consider using under the right circumstances. You could contact us. Our information's attached. You can contact lawyers that you have relationships with. But it's something that this webinar, hopefully, as the CRF webinar did, provide you with more tools as credit executives. With that, Roxanne, are there any questions that have been posted?
Not one question. If you want to wait a few seconds on the line before we shut down.
Sure.
Yeah, I would just chime in while we're waiting, Roxanne. This is Keith speaking. As Scott said, there are times we're painting a very cautionary tale here, but there are times when it may be a good idea to file an involuntary. And I've seen debtors spiriting away assets. They can't be restrained in any other way. We mentioned the debtor being incapacitated. Well, what about if they're just dishonest or totally incompetent? I mean, there are a lot of times when you may need to call your lawyer and say, hey, we need to do something, and obviously then you want to make sure you follow the rules of the road so you don't run into any problems we discussed here today.
I just received a question. Do you need to file a motion for 503B9 claims?
The answer to that, which I touched upon earlier, is normally you do not. As opposed to reclamation claims, which encompass a 45-day period, you are automatically granted this administrative status. However, how and when it gets dealt with may vary from case to case. In a large, whatever that means, Chapter 11 commercial case, it is routine for good debtor counsel on the first day of the case to file a motion before the court to instruct and set forth to administrative potential creditors, 20-day goods creditors, how it's going to work. And in the normal case, what they try to do is they set up a timeline for people to send in their request to be paid on 20-day goods. They set up a process to reconcile. We went through some of the issues that might arise in a reconciliation. And then they set up a process for payment. Payment might be at the end of the case. More often than not, payment can be now, but payment now is usually conditioned upon the debtor and the vendor agreeing to credit terms. So if the debtor is going to give you $10, the debtor is going to want at least $10 back. And that happens in the normal case. In the abnormal case where nothing is being done, a 20-day goods creditor should consider making a motion before the court to compel some action on the 20-day goods claim.
Okay, I have another question. How do you go about retaining other creditors to become petitioning creditors with you in involuntary bankruptcy?
Well, first you belong to, among others, Credit to Be, and you know who your colleagues are out there who have similar interests. And you undoubtedly know, because of your colleagues out there, who sells to these companies. And there is nothing improper in picking up the phone and asking Johnny Jones, hey, I'm stuck by customer A. I've spoken to the CFO. He's told me they're going to file a bankruptcy petition. I have a 20-day goods claim. It's evaporating. What do you look like? Do you want to file an involuntary with me so we could try to preserve our claim? And it's basically, who do you know that gets you your other petitioning creditors? The experience that one manufacturer had in the case that provoked this panel, he contacted two other giant companies. He is an international giant company, and each of the other two declined to participate because, as a policy matter, this is one of these poll survey answers, his companies, their companies, did not like to participate in involuntary petitions and be accused of big guys beating up on little guys. So it's dialing for dollars to find another petitioning creditor.
And I would also add, Roxanne, this is Keith, that sometimes, as Melanie pointed out, in the typical case when you need 3 or more petitioning creditors, and say you're the large creditor with $15,323, and you just need someone else for another $1 or $2. I had a client actually walking through the debtor's office, noticed Deer Park as a water cooler company, and WB Mason as a paper supplier. And obviously those are 2 creditors right there. So you can just open your eyes next time you're at the debtor's facility and maybe find 2 that way.
By the way, on the costs associated with being a petitioning creditor, which we generically touched upon, sometimes those costs, which in an uncontested involuntary petition are relatively small, in a contested they could be bigger, but costs usually are dealt with either pro rata, divide up bills into 3, or sometimes based upon the size of your claim. And so Keith's comment about if you have one really large creditor, they may either be asked or offer up to take up their percentage share of the costs of the involuntary petition.
Thank you. There are actually no further questions at this time. So if anyone does have any questions, I'll provide Keith, Melanie, and Scott's email when I send the PDF version of the presentation letter today, and you'll be able to follow up directly. But with that, we're actually going to close today's webinar. I would like to thank Keith, Melanie, and Scott for taking the time to present to our group today, and thank all of today's attendees for taking time out of their day to join us. Thank you all again, and we look forward to seeing you at our next webinar. Have a great day, everyone.
Thank you.
You're welcome.